much more money, much more in the way of resources to schools in very wealthy towns and much less to schools in not wealthy towns. And it says that's not adequate under our state constitution, and it also violates the Equal Protection Clause of the 14th Amendment. So now we have two grounds of decision. One, the 14th Amendment, which is a federal issue, and one is the meaning of a clause in the state constitution. And if the court says, state court says, hey, our own constitution is sufficient to justify this, then they have an independent and adequate ground, even if they're wrong about the meaning of the Equal Protection Clause in the 14th Amendment. Petition to the United States Supreme Court for certiorari denied. Because if the United States Supreme Court took the case and decided you're wrong, which they would because they've decided that unequal educational opportunities is not a violation of the 14th Amendment, see the case involving San Antonio School District that's in your outlines. Because wealth is not a suspect classification, education is not a fundamental right, therefore such school financing is not a violation of the U.S. Constitution, it wouldn't change the outcome because the state court of Connecticut, which actually did this, had an independent ground for its decision, independent state law ground for its decision. So let's leave it at that. You're going to see this coming up over and over and over again. When the state has an independent and adequate ground, but also states a federal ground, then the Supreme Court will not hear the case because even if it decided the state was wrong about the meaning of the U.S. law, it would not change the outcome. Independent, adequate state ground. Lack thereof means there's no case because all the court would give is an advisory opinion. Just a few more topics relating to the judicial power. There's a doctrine called abstention. In fact, there are two different doctrines called abstention. And abstention often appears as a choice on the multi-state portion of the bar examination and has almost always in the release questions been a wrong answer. But you can't just say abstention is always the wrong answer because it could be a correct answer. Two different circumstances in which federal courts are told by the Supreme Court that they must or shall or should abstain from hearing the case. Number one, the old version, federal trial courts should abstain from deciding a case and send it over to the state courts or let it be brought over in the state courts when the case involves an unsettled interpretation of the meaning of state law. We have a state statute. The plaintiff challenges the state statute, and the meaning of the state statute has not been settled. It's not clear. And if it's interpreted one way, then the statute is perfectly constitutional. If it's interpreted another way, it's not. But we don't know the meaning of that state statute. Who is supposed to determine the meaning of state statutes? Primarily and at first, the state courts. So the federal court should abstain from determining a case when the case turns on an unsettled question of state law. It should let the case be taken over to state courts to interpret the meaning of the state law, and only then brought to the federal court for ultimate determination. That's called Pullman abstention from the famous Pullman case. There is a second, more recent doctrine of abstention that says, created originally by the late Justice Rehnquist, that if there is a proceeding in state court and a proceeding in federal court at the same time about the same matter, the federal court should abstain because of the federal-state relationship. If there's a pending state case, then the federal court should generally abstain and let the state court make the determination. This applied originally in only criminal cases, but was extended to civil cases and even administrative cases. So if we have begun a substantial proceeding in state court and in federal court, the federal courts will dismiss and say, get your case decided in state court, and if you're unhappy with what the state court says about your federal claim, you can petition to the Supreme Court, which turns out to be nonsense, but we'll leave that for another day. So, two doctrines called abstention. Read more detail in your outline understand that usually they are wrong answers on MBE, but they can be right answers if it meets those requirements. One more big topic under this concept of a judicial case or controversy, and that's the concept of a political question. Non-justiciable political question. Well, pretty much any question is arguably political, but the Supreme Court says some kinds of questions are such that we should dismiss them, that the trial courts even should dismiss them, because they are political questions that are committed by the Constitution to another branch of government. They're not something that we as judges have any particular competency to decide because they're committed to another branch of government. Right, like the president's power over foreign affairs, the president's powers as commander-in-chief, the president's power to grant pardons, Congress's power to hold impeachments. That holding of impeachments and what rules are going to be used was committed by the Constitution to Congress, and so we should not hear those kinds of things that have been committed to a different branch of government. They are political questions. Done with case or controversy, but there's one other area, not nearly as much tested as it might be, but you need to be aware of, and that's the 11th Amendment. The Constitution, as written originally, gave no reason why a person could not sue in federal court against his own state or another state asking for damages. The 11th Amendment was added, obviously, after the first 10, and it basically has been interpreted to mean that federal courts cannot hear cases that they could otherwise hear that fit within the kinds of subject matter, diversity, federal question, whatever, but they cannot hear cases in which a private person is asking for damages from his or her own state, or even an injunction against his or her own state. Federal courts shall not hear cases directly against a state by citizens of the state or by citizens of another state. However, very importantly, federal courts can hear cases by private persons asking for an injunction against a state officer. So rather than asking for an injunction against the state of Connecticut, one can sue and ask for an injunction against the Attorney General of the state of Connecticut. That's appropriate. One cannot bring a suit against the state of Connecticut or New York asking for damages for past behavior generally, but one can bring a suit against the state treasurer saying that in the future the treasurer, to abide by federal law, must in the future make payments. Not payments for past injury, but future payments. Those are exceptions to the 11th Amendment keeping us out of federal court. Let's let it go at that for the 11th Amendment, and I'm going to stop and take a little break. Okay, so I just completed looking at the powers of the central government as created by the Constitution, the executive, the legislative, start again. So I've just finished a brief overview focusing on the most important issues on the powers of the various branches of government and their relationships, the legislative power, the executive power, and the judicial power. There's a lot more I could say, but then it would run 6 or 8 or 10 hours. I'm now going to move on to our second big topic, federalism. As soon as we see any problem involving states, any question in which a state has done something like passed legislation, or a subdivision of a state, a town, a county, a school board, any subdivision of a state, or any officer of a state, an attorney general, a governor, anybody who works for the state has done something, the question will be, what impact does the Constitution have on that? And it's a very different approach than with the central government. So talking about federalism issues, the Constitution does not give the states their basic powers. The theory is the states were sovereigns before the adoption of the Constitution. They remain sovereigns with some limitations on their sovereignty imposed by the Constitution. The states have the police power. That is, the states can pass legislation for public health, safety, welfare, morals, without any specific limitation or grant by the Constitution. The Constitution doesn't give them these powers. But the Constitution does limit what the states can do, both because of the creation of this new central power and because of individual rights as limits on what the states can do. The key questions in terms of federalism are these. Number one, what if the federal government and the states have both acted in an area where the feds are trying to regulate the states or the states are trying to regulate in some way the feds? And the key to this, one of the most important provisions in the whole of the Constitution, is what we call the Supremacy Clause. In Article 4 of the Constitution, it says, "This Constitution and treaties and statutes properly adopted under this Constitution shall be the supreme law of the land, anything in state law notwithstanding." It means states are preempted or blocked by any federal law on point. The Constitution, statutes, or treaties can prevent states from doing what they otherwise would have been able to do. Okay? This includes, of course, statutes as well as treaties of the federal government. So a statute is passed, and if there is any conflict with any state law, the state law cannot be enforced. If there's any direct conflict, federal law says speed limit shall not exceed 55. Well, federal law says whatever it says, and state law is inconsistent therewith. State law can't be enforced. Or Congress, in an area where Congress appropriately can, says we are regulating this whole area of human behavior. All of labor law will be controlled by us or by agencies we have created. Then even if there is no direct conflict between federal and state law in the area, Congress has, if it has been appropriately done, taken over the area and state law cannot be enforced. Or there's federal law that aims at one goal and state law seems to impede achieving that goal. State law cannot be enforced. The Supremacy Clause and preemption are very important concepts. Read everything in your outline 5 times and understand it and say, this is important to understand. To recognize anytime the feds and the states have acted, feds appropriately control if there's a conflict. Okay? That's the first aspect of federalism that is tested and you must understand. Second thing this federal system does that affects the states is, because there are the separate states and there is this central unifying power, the question is, what effect does this have on the relationship between and among the states? And there's actually several provisions that affect this, but the most important perhaps is the Full Faith and Credit Clause. The Full Faith and Credit Clause says that each state shall give full faith and credit, whatever that means, to the decisions of other states. Most simply, it means that if you go to a state court in Connecticut and get a judgment, and the judgment says $100,000 damages against a named defendant, you can take that piece of paper, your judgment, and you can take it to another state in which the defendant has property, and you can get the judgment enforced against the property in that other state, and the state must recognize the judgment of Connecticut, with some caveats. Only if Connecticut had subject matter jurisdiction and personal jurisdiction, which includes if those issues were disputed and actually decided by Connecticut. But you'll see the limitations on it. The basic concept is states must give credit to the decisions of other states. Could be a lot more complicated. I'll leave it at that. This concept is also tested on essays quite a bit in the area that is known as conflict of laws. It has not come up a lot on the multi-state, but be aware of it. A couple of other things about federalism. There is in Article 4 a provision that says states must not discriminate against citizens of other states as to basic rights. The Article 4 Privileges and Immunities Clause has been interpreted to mean, well, number one, it only applies to human beings, actual human beings who are citizens. It does not apply to corporations. They're not citizens for purposes of Article 4. It does not apply to aliens, that is, non-citizens. It only applies to citizens of other states, and says states may not discriminate against citizens from other states. That's an individual right, but it also has to do with the relationship of the states. And it only applies to fundamental rights. See more detail as it comes up in the classes. Caveat, compare, there is another clause in the Constitution, Privileges and Immunities Clause. The one I was just talking about, a state can't discriminate against citizens of other states, is in the main part of the Constitution, Article 4. But in the 14th Amendment, as I mentioned in the first hour, there is a clause, no state shall deprive any person of the privileges and immunities of citizens of the United States. Now it's not talking about discrimination in favor of the state's own citizens against citizens of other states. It's saying that a state can't deprive a person of privileges and immunities of being a citizen of the United States. That has been interpreted, as I said in the first hour, to mean almost nothing, to apply to almost nothing, because the Supreme Court in the Slaughterhouse cases said the only privileges and immunities of being a citizen of the United States are those privileges that one has only on account of United States citizenship, and not on account of any other reason. And that means basically the right to petition your congressman. Because you are a citizen of the United States, you can petition your congressman. Until recently, that was about the only thing that the Privileges and Immunities Clause of the 14th Amendment seemed to require, as a result of which no statute had ever been found unconstitutional under the Privileges and Immunities Clause of the 14th Amendment. It was basically read as meaningless. Only very recently, in the mid-1990s, did the court come back and say, among the privileges and immunities of being a United States citizen is the right to travel interstate, which had been recognized previously. But now it said, because of the privileges and immunities of the 14th Amendment, a state would be violating that clause if it had a durational residency requirement for receipt of welfare benefits. Meaning, state says, if you move from another state into this state, your welfare benefits will not be what they would have been if you'd lived here for a long time, but rather will be limited to the benefits you would have received in your home state. So now it's saying if you use your right to travel interstate and come to our state, we're not going to treat you the same as if you'd been here for a long time. We're going to give you lesser rights. That's a violation of privileges and immunities of the 14th Amendment. So that's about the only case in which so far that's been applied. But in terms of federalism, that's really not so important. So for federalism, we have the Supremacy Clause, the relationship of the federal government to the states. We have full faith and credit between the states. We have the privileges and immunities of Article 4, no discrimination against citizens of other states as to fundamental rights. And there are a few other things that sometimes apply that I won't go into today, but that might come up later. But now let me back up a step. If we have these rules pertaining to the relationship between the states and between the states and the federal government, there are a couple of situations that come up on the test all the time. Can the federal government regulate the states? Can the states regulate or tax the federal government? Understand what I'm saying here. If there is a statute of the United States that regulates all behavior or taxes all behavior of a certain kind, can that statute be applied against the states? Can the states be taxed by the federal government? Can the states be regulated? There is a law of general applicability that says children under the age of 16 shall not be employed, or a minimum wage for all persons shall be $7.50 an hour. Can that be applied to employees of a state? And generally the rough and simple answer is yes. If it's not discriminating against states, it's not a specific rule as to what states can do, but it's a rule about what anybody can do. If it's a rule discriminating against states, no, that's different. A couple of specific instances. Can the federal government order the state to pass legislation? Or can the federal government require states to have their officers enforce federal law? And as to both of those things, in terms of the relationship between the federal government and the states, one might think, well, if the federal government is supreme, then why can't Congress, in an area where it has power, tell the states you must pass a particular law or you must provide people to enforce a particular law? But in recent years, those issues have come up to the Supreme Court, and the Supreme Court has said, for a variety of reasons, the state sovereignty would be so diminished by the states being subject to orders by the federal government to do this or to pass this legislation that we will not allow the Congress to do this. Nothing explicit in the Constitution says that, but by the structural implications of the way the government was set up, the states would be so diminished in terms of their significance by letting the federal government say to the state legislature, you must pass a law. So I'm a member of the state legislature and I'm ordered to not vote my conscience, but to do something because Congress said I must vote a particular way? No, can't do it. Or I am a state police officer and the feds say you must enforce federal law. Well, I've got a lot to do with my time. I'm obliged, even though the state government is paying my salary, the feds aren't, I'm obliged to go out and enforce federal law. Why is the federal government hiring me? Let federal officers do it. So those two instances, the Supreme Court has said, no, federal government cannot, federal legislation cannot require states to pass a law. Federal legislation cannot require state officers to enforce federal law. Compare what I said earlier. Federal government can offer the states money under the spending power and say, if you take our money, you need to have a 55-mile-an-hour speed limit. That's in essence requiring the states to pass a law, but not really requiring it, only making it a condition of receiving money. That's how the feds can do it. Okay? So this is federal regulation of states. As long as it's a neutral law applied both to the state government and to everybody, generally it's okay for Congress to do it. However, reverse gears. Imagine the state government has a general rule about taxation or a general rule of regulation. Can it enforce its rules against the federal government? No, no, no. Under the Supremacy Clause, the federal government is supreme, and if the states can regulate or tax the federal government, this undermines the supreme status of the federal government. So the state may never directly tax, may never directly regulate federal government or its employees. Never. Okay. Those are the most important concepts of federalism, except for what's called the Dormant Commerce Clause. This is a major area for you to understand and a major area of testing. The Dormant Commerce Clause. Dormant means sleeping. How can a clause sleep? It's metaphorical language. Another way of putting it is the implied limitations of the grant of the commerce power to Congress. Here's the concept. When the Constitution says the legislative power of Congress shall extend to commerce between the states, that implies that the states are limited in what they can do in the way of regulation of commerce between the states. This could mean that by the grant of that power to Congress, the states may never do anything that has any effect on commerce between the states, but that would make the states almost impotent because almost everything might affect interstate commerce. So in fact, the limit on the states of just the grant of power has been more limited. By granting power to Congress, here's the approach. If Congress has actually exercised its power under the Commerce Clause, and there's any inconsistent state legislation, it's preempted, Supremacy Clause. If Congress has exercised its power to say that a state can do something that it otherwise couldn't do, then the state can do what it otherwise couldn't do. So if we have any federal legislation in relationship to the state legislation, if it conflicts with the state legislation, it preempts. If it authorizes the state legislation, it's okay. But if we have no federal legislation on the matter at all, then we are in the situation of the so-called dormant Commerce Clause, or the implied limitations of the Commerce Clause, or the negative implications of the grant of commerce power to Congress. Any of those terms will do. Then the Supreme Court has, over 200 years, worked out what now amounts to a couple of basic tests. The most basic is, if state legislation discriminates against interstate commerce, it is no good. Unless discrimination by the states against commerce between the states is no good, is unconstitutional, unless it fits one of a class of limited exceptions, the most important of which are state legislation that discriminates against interstate commerce is okay if, kinds of scrutiny, if the state legislation advances an important governmental interest and is narrowly tailored, is a good fit, does so in some way that fits what they're allowed to do. A pretty high level of scrutiny. That is, the court will look and say, what is the purpose of the state? Is this an important purpose? And does the state legislation really carry out that purpose? Only if the state can show those things is the state allowed to do something that actually discriminates against interstate commerce, and that's rare. See the case Squibbs in your book. Second, a state may do something that discriminates against interstate commerce if it is what has been called a market participant, if the state participates in the commerce itself. The state has its own business. It has, in one case, a cement plant making cement. If the state has a cement plant making cement, it can discriminate in the sense of saying, we will sell our cement first and only to companies in the state, or only to companies outside the state. If we have excess, the people in the state get priority. As long as what the state is doing is actually engaging in a commercial activity, then it may discriminate against interstate commerce. But there are limits on what it can do. Again, see the case Squibbs. I'm not going to go into all the detail. So discrimination, no good against interstate commerce unless either justified by an important governmental interest and substantially related to that interest, narrowly tailored, or unless the state is a market participant. Rule number one. But suppose we have state legislation that treats all commerce the same, no discrimination against commerce that goes across state lines. What then? Second test. State may not unduly burden interstate commerce, unduly, unfairly, unreasonably burden interstate commerce. Excuse the sniffle that I've got. Now here's a key and critical point. You might remember from our first hour that I said economic regulation, when challenged as a violation of due process, economic regulation when challenged as a violation of equal protection, if we don't have some suspect classification, if it's just economic regulation and you challenge it under the Due Process Clause or you challenge it under the Equal Protection Clause, the court will use a scrutiny, how do I approach this, that says we defer to the states, and the person challenging the statute must show that there was no conceivable rational basis related to a legitimate aim of state government. No conceivable rational basis related to a legitimate aim of state government, and only then would it violate due process or equal protection. But the very same act of the state, if we challenge it not under the Due Process Clause, not under the Equal Protection Clause, but we simply name a different clause, we say Commerce Clause. If we challenge it under the Commerce Clause, instead of the court deferring, the court will say, if this thing happens to affect interstate commerce, then we're going to say now the state has to justify what it's doing in a significant way. We're going to examine it, scrutinize it, evaluate it much more closely, and we're going to say that a state may not unduly, which means unreasonably or unfairly, burden interstate commerce. So suppose that a state has, as in one famous case, a rule that says trucks that go across or use the highways of our state must all use a particular kind of mud flap behind their tires to prevent mud from spattering on other people. You can't operate a truck on the roads of our state unless you have these flaps. No discrimination against interstate commerce. It might, right, affects trucks that go across the state into other states, but it does not discriminate. It treats trucks that only operate within the state and trucks that operate interstate, it treats them all the same. No discrimination. But does it violate the Due Process Clause or the Equal Protection Clause, bringing those in? Well, only if there's no rational basis for the legislature to have said, we want trucks in our state using these mud flaps. And if there is any evidence from which anybody conceivably could find that these mud flaps would promote public health, safety, or welfare, these mud flaps reduce the amount of mud that might be thrown onto cars that cause car accidents, any evidence that might support that, we defer. In fact, we're not going to hold a hearing on that. That's up to the state. The state legislature could have found that this kind of mud flap better protects public safety. End discussion. Rational basis. The plaintiff loses. However, if instead of using those other clauses, equal protection, due process, we go back to our dormant commerce clause, now instead of rational basis, we say state may not unduly or unreasonably burden interstate commerce. And now we get a different way of scrutinizing or evaluating that legislation. We say state legislation says you must have these mud flaps on trucks that go across our state highways, are saying if you're going across Indiana into Illinois and then out Illinois on the other side, if you don't have those mud flaps on your truck when you get to the borders of our state, you must stop your truck, put on those mud flaps, take off whatever you had put on these mud flaps, and when you get to the other side, if you want to take them off, you can. Well, that's going to be a fairly substantial burden on interstate trucking as it goes through the state. It's not discriminating, it's saying everybody must use them, but it's going to have a big impact potentially on interstate carriers, especially because other states don't require this. In fact, other states may require a totally different kind of mud flap. So you come into Indiana, you have to have on one kind of mud flap. You come into Illinois, you have to switch your mud flaps. This will slow down and greatly increase the expense of interstate commerce. So now we do an actual assessment, not deferring to the legislature, but asking, is this an unfair or unreasonable burden on interstate commerce? Now you see why, on a fair number of questions among those that have been released over the years, when they have given us a choice, what's the best basis to challenge state legislation? They say due process, equal protection, dormant commerce clause, and something else. The answer is generally going to be, when you evaluate, going to be dormant commerce clause, because equal protection, due process use rationality, deferral standard, deference standard, and the commerce clause requires a greater burden on the states, requires greater judicial scrutiny of what the state has done. Okay, so that's it. Dormant commerce power. Number one, if the feds have acted, preemption. Number two, if the states discriminate, generally no good unless it fits one of the exceptions, substantial governmental interest and narrowly tailored, or market participant, or does the statute of the state unduly burden interstate commerce? That's how you're going to approach any state economic regulation that might have any effect on interstate commerce. Okay. Stop. That's the end of what I intend to do with federalism issues in this particular introduction. Hereafter, we need to talk about individual rights, which I will do on another DVD.